Transfer pricing is often said to be not an exact science, and for good reason. It involves judgment, interpretation, and assumptions that vary across businesses, industries, and jurisdictions. For multinational enterprises, this uncertainty often leads to audits, disputes, double taxation, and long litigation cycles. To address this, tax authorities around the world have adopted a powerful tool called Advanced Pricing Agreements, or APAs. In this video, we'll explore what APAs are, how they evolved globally, and how the UAE has introduced APAs as part of its corporate tax framework. Transfer pricing determines how prices are set for transactions between related parties. Because these prices directly affect taxable profits, disagreements between taxpayers and tax authorities are common. Historically, MNEs have also used transfer pricing to shift profits to low-tax jurisdictions, leading to base erosion and profit shifting, or BEPS. As a result, tax authorities worldwide strengthened enforcement, but post-facto audits proved inefficient, often resulting in uncertainty, cash flow strain, and double taxation. This created the need for a proactive mechanism, one that provides certainty before transactions occur. That's where APAs come in. The concept of APAs dates back to the late 1980s. Japan introduced a formal APA framework in 1987. The United States followed, with the IRS concluding its first APA in January 1991 and formally launching the program through Revenue Procedure 91-22. Over time, countries like the UK in 1999 and India in 2012 adopted APA regimes. The OECD later endorsed APAs in its transfer pricing guidelines, especially encouraging bilateral and multilateral APAs to prevent double taxation. Globally, the objective has remained the same: tax certainty, predictability, and reduced disputes. With the introduction of Federal Decree Law No. 47 of 2022, effective June 2023, the UAE formally embedded transfer pricing principles into its corporate tax regime. Importantly, UAE transfer pricing applies to both cross-border and domestic-related party transactions. Article 59 of the Corporate Tax Law gave the first legislative signal of APAs, allowing taxpayers to seek clarifications from the FTA. This was followed by FTA Decision No. 2 of 2025, referencing APA's Cabinet Decision No. 174 of 2025, introducing APA fees Cabinet Decision No. 65 of 2020, as amended, consolidating the fee framework from 1st January 2026. Most recently, the FTA issued a detailed APA guide outlining the procedural framework. An advanced pricing agreement is an agreement between a taxpayer and the tax authority that determines, in advance, the arm's-length pricing methodology for specific controlled transactions. It typically covers a defined period and aims to reduce transfer pricing risk, avoid audits and disputes, prevent double taxation, provide long-term tax certainty. There are three main types of APAs. Unilateral APA, an agreement between the taxpayer and the UAE FTA. It provides certainty only from a UAE perspective and is not binding on foreign tax authorities. Bilateral APA, agreed between two tax authorities through the mutual agreement procedure, offering protection from double taxation. Multilateral APA involves more than two jurisdictions and provides comprehensive certainty. In the UAE, the FTA is adopting a phased approach. Currently, only unilateral APAs for domestic transactions are accepted from December 2025. Cross-border unilateral APAs are expected from 2026. APAs are intended for material and complex transfer pricing cases. Generally, eligibility requires controlled transactions of AED 100 million or more per tax period. Significant uncertainty in determining arm's-length pricing. Key points: transactions under safe harbor are excluded. Domestic transactions may qualify where different tax rates apply, such as free zone and mainland transactions. The FTA may accept applications below the threshold with strong justification. The fees are non-refundable. Fresh APA application, AED 30,000. APA renewal, AED 15,000. Stage 1. Pre-filing consultation. The FTA assesses suitability. Initial assessment results are communicated within 60 business days, and additional information must be provided within 40 business days. Stage 2. Filing the application. The FTA conducts a detailed review, including economic analysis, contracts, and business conduct. Applications may be rejected for weak documentation, inconsistencies, or tax avoidance concerns. Stage 3. Evaluation and negotiation. The FTA proposes its transfer pricing analysis. The taxpayer has 30 business days to respond. If agreement isn't reached, the application may be closed, with no fee refund. Stage 4. Conclusion and implementation. Once agreed, the APA becomes binding. Annual compliance filings are required, and any changes in facts must be reported. Renewals are possible where there are no material changes. The process is simplified and does not require a fresh pre-filing consultation. The introduction of APAs marks a major step in the UAE's transfer pricing journey. While the program is currently limited in scope, it reflects the FTA's commitment to tax certainty, transparency alignment with OECD best practices. For MNEs and large domestic groups, APAs offer a strategic opportunity to proactively manage transfer pricing risk in the UAE. If you found this useful, like the video, subscribe to the channel,